Okay, class, we're picking up with Chapter 15, Part 3, dealing with protection for debtors. We're going to talk a little bit about a few protections under state law, and then we're going to go right into bankruptcy, which is the big topic and will be covered in this Part 4 and I think a little bit in Part 5 as well. Okay, so there are some consumer protection statutes that protect debtors' rights. Here on these slides we're going to be talking basically about homestead exemptions that apply to real and personal property, and these are state laws. There are also some federal laws like the Fair Debt Collections Act, which prevents third-party collectors from abusing the collection process. We'll be talking about those in later chapters. Okay, so states have some laws that protect, and these homestead exemptions will include a certain amount of equity in a person's real property. Usually in most states that requires that it be a family home. We want to protect shelter so that people are not made homeless. I have to state that Georgia's homestead laws, both personal and real property, are not very high in the amount and therefore are not very useful. These parts of the home are personal property that are protected under the homestead laws, are free from the claims of unsecured creditors or trustees in bankruptcy. Personal property can be exempt from the satisfaction of judgment debts, including things like household furniture up to a specified dollar amount, clothing and certain personal possessions such as family pictures or a Bible, an automobile, a vehicle, a truck, up to a certain amount. Obviously your Lamborghini would not be protected. Certain classified animals like livestock. Now the third one here on this slide is the most important probably, and that's what we call tools of the trade or equipment that the debtor uses in a business. So if you're a plumber, you're going to be allowed to keep your tools to continue doing your plumbing, because we want people to be able to earn their living and continue to pay their debts. That's it. Okay. So now we go into bankruptcy and the goals of bankruptcy. The goals of bankruptcy are to protect the debtor by giving him or her a fresh start without creditor's claims. So you don't have to be worried about being sued or any of your property being taken once you've completed a bankruptcy. That's the protection for the debtor. For the creditor, we want to make sure that all creditors are treated equally. We don't want to give an advantage to one creditor over another. In other words, just because somebody goes first after the debtor, even though they have a less significant claim, without bankruptcy they might get a benefit over the other creditors, and the assets of the debtor dissipate before the other creditors can collect. So we're going to have a fair process to treat the creditors all fairly. When I first started teaching in this area, I was reading a book about bankruptcy, and the author said that one of the purposes of bankruptcy law was to grease the wheels of a capitalistic economy. And what that means is that by giving the debtor a fresh start, they now become a consumer again, and they're putting money back into the marketplace, which helps the sellers and the manufacturers, and it flows through into the economy. So it, quote, greases the wheels of a capitalistic economy. So bankruptcy is primarily federal law, and we have special courts where you go to file bankruptcy. These are called bankruptcy courts. The Bankruptcy Code is found in Title 11 of the United States Code. Chapters 1, 3, and 5 are basic provisions that apply to almost all the other chapters. The main chapters of relief are chapters 7, 11, 12, and 13. So we're going to treat 11, 12, and 13 somewhat as a group, because those are what we call reorganizations. They allow certain debtors to reorganize their debts, to pay them off either completely or partially over a longer period of time than they would have been allowed without a bankruptcy, to get a discharge and be free of those debts. Chapter 7 is different. It's a liquidation. In that situation, the debtor's property is taken, sold, and the creditors are paid off. Okay, so a liquidation under Chapter 7 is also sometimes called a straight bankruptcy or an ordinary bankruptcy. The court has an appointed person called a trustee. The assets are gathered by the trustee and distributed, sold, and the proceeds distributed to pay the creditors. If all this is done, then the debtor receives what is called a discharge, and that means that they're protected from any collection activities by any of those creditors. Now, it used to be that anybody could file a bankruptcy under Chapter 7. Now there are restrictions. The reason for this is that people were taking extreme consumer debt, like $50,000 in credit card debt, and bankrupting it, and that was harmful to the banks and lending institutions. So the law was changed, and now there's what's called the means test. So before you can file a straight 7 bankruptcy, you have to meet the means test. Okay, and that is to prevent substantial abuse of that Chapter 7. Okay, so the purpose of the means test is to keep upper income people from filing a Chapter 7 and abusing that process when they're capable actually of paying off their debts under a Chapter 13. So the fundamental result is that more people are filing Chapter 13s than used to, rather than filing 7s, because they can no longer do so with the means test being applied. Okay, so the basic formula for the means test is to look at the debtor's average monthly income and compare it to the median income for the area, the geographic area where that person lives. If their income is below that median income, then there's no presumption of abuse. If it's over, there's a presumption of abuse that requires certain things to overcome that presumption. Okay, so bankruptcies can either be voluntary or involuntary. A voluntary bankruptcy is where the debtor files the bankruptcy. An involuntary bankruptcy is where the creditors file against the bankrupt, the debtor, to make the debtor go through bankruptcy. Now, when the bankruptcy is filed, there's what's called an automatic stay. This is extremely important. This is one of the things that sometimes was abused under the old law. So an automatic stay basically stops all collection efforts against the debtor. So this would be lawsuits and any other attempts to collect a debt. And it continues until the bankruptcy is completed or dismissed. Now, if it's violated by a creditor, it gives rise to a lawsuit by the debtor for damages, costs, attorney's fees, and in some cases, punitive damages. There are some exceptions to the automatic stay, situations where debts are not prevented from being collected. Domestic obligations like alimony and child support, certain family law issues, investigations by a securities regulatory agency are allowed to continue. Certain statutory liens for property taxes are not stayed. A secured creditor or other party in interest can petition the bankruptcy court for relief from the stay. We sometimes refer to that as asking the court to lift the stay. If the court grants that for whatever reasons allowed by law, the stay automatically terminates within 60 days after the request unless the court extends that. If it's secured property, it terminates in 45 days after what's called the creditor's meeting, unless the creditor redeems or reaffirms that debt. We'll talk about reaffirmation later. The debtor cannot keep the secured property even if they continue to make payments on it without reinstating the rights of the secured party. Bad faith. This is if the person is using the process to get the automatic stay only to delay proceedings, then to dismiss their bankruptcy, forcing the creditors to start over again, and then they file another bankruptcy to stay anyway. If the debtor had 2 or more bankruptcy petitions dismissed in the previous year, the code presumes bad faith and the automatic stay does not go into effect. It terminates 30 days after the petition is filed if it was dismissed within a previous year. Now, what about fraudulent transfers? Okay, a fraudulent transfer is where a person takes property, whether real or personal, that they own, and transfers it to another person in contemplation of possible bankruptcy so that they don't lose that property. It's fraudulent because they're trying to hide that property from the bankruptcy court and the creditors. Their intention is to eventually get that property back. So it's usually transferred to a relative or a friend with the knowledge that it's just temporary until they get through the bankruptcy process, and then they get the property back. So that can be set aside by the trustee. The trustee may avoid the fraudulent transfer if it's made within 2 years of filing the petition, or where there was actual intent to hinder, delay, or defraud a creditor. When a fraudulent transfer is made outside the code's 2-year limit, the creditors can seek alternative relief under state laws. Okay? So, when you file a bankruptcy, there are certain property that you have that's exempt from being taken, and these are those exemptions, similar to what we saw in the homestead exemption. A debtor's home, a vehicle up to a certain value, household goods, furniture, and appliances, jewelry up to a certain amount, tools of the trade, a portion of unpaid wages, and pensions. Okay, so we're going to stop there with part 3 and go on with part 4 in a minute. Not a minute, but in your next video. Please remember the magic word for chapter 15 is bankrupt.